It's Thursday morning. Good morning, everyone, and welcome to the program. I am Nifemi Oguntoye. Yesterday, the Senate confirmed Justice Tanko Muhammad as substantive Chief Justice of Nigeria, and that was after 2 hours of screening at the floor of the Red Chamber. Recall that Justice Muhammad was appointed acting CJN after the controversial suspension of the former CJN Walter Onohen. Well, we're talking about the next phase for the Nigerian judiciary under its new leadership, and I'm joined this morning by lawyer and human rights activist Libros Oshoma. Good morning, and thank you for joining us.
Good morning, Ifemi.
So a lot of people are saying that do we already have a closure on the Walter Onohen case? The fact that I had a lawyer on the show some time ago who was saying that there was nothing wrong in the president suspended the CJN as at that time. Do we seem to understand the position of the law in this regards?
There are lots of mix-up, on the issue. Also, depending on your political leaning, depending on the political leaning of the person who's discussing the issue, be it a lawyer, a senior advocate, or even a judge, depending on the political leaning. So you see a slight tweak, But as it stands, you can't say that the Onoge issue is still subsisting in terms of the occupation of that office, because Onoge, with his own hand, did write a resignation letter. And so there can't be a vacuum. And so since he has resigned during the pendency of the matter, there's need to fill that.
I understand that quite all right, but recall that the substantive CJN, while it was being screened yesterday, mentioned the fact that the judiciary is corrupt and there's need to punish erring judicial officers. If the former CJN was allegedly corrupt, there were allegations of false asset declaration. I'm talking about a closure that gives us a legal example for future purposes.
That's now not the business of the judiciary.
Okay.
Because there's need for us to understand that the judiciary are not prosecutors. The judiciary adjudicates over matters. It is not their responsibility to initiate legal proceedings or prefer charges against, an alleged corrupt person. It is their responsibility to adjudicate. And so, for the case of Onoge, it is the duty of the executive to say, well, the matter before us had not been concluded or had been concluded. I know that the Court of Appeal, did give a judgment on the matter on the proprietary or otherwise of the purported suspension of Onoge. Even though the Court of Appeal didn't go into the merit of the matter, but they did say that the actions had been overtaken by event, and so there was no need to go into the merit of the matter. And so that ended that. But there are two legs here. One is the civil, the other one is the allegations of criminal infraction. And so those ones are for the executive to deal with. That's not necessarily for the judiciary. And so I had expected that matters like these, because of the sensation that it created, that to be nice and necessary to follow it through. So as the moment you leave some, issues hanging, it lays credence to the fact that, these actions were carried out to achieve an aim, in which once it's been achieved, there was no need going further with it. And so, you leave everything, hanging. And so there's no conclusion on it. It would have been better if there were, a conclusion on the matter.
Right. And then the executive did take the former CJN to the CCT, and the tribunal came up with its verdict, one of which was that he was suspended from official engagements for 10 years. Do you consider that some form of closure in this matter?
For the tribunal, really, the tribunal's job is to indict. And once you are indicted and you are not cloaked with immunity, it is now the responsibility of the state's, security or prosecutory apparatus to now bring the required charges before you, against you, and then so as to, if possible, get a conviction. But just saying, go and sin no more, don't hold office for 10 years. You know, you have been indicted and so you can't hold office for 10 years. You know, for me, that's not a closure of the matter. It leaves a lot, you know, of issues, like I said, hanging. And so
amazingly,
there are no conclusions. So there are still some loose ends. And so what happens, like Justice Kayode Esho, of blessed memory, during the Justice Naron and Okutumba Kalajaye, you know, issues and the SMSs, you know, when he was asked, you know, to comment on them, you know, such crisis, he did say that the way, you know, the judiciary was going, that we're gradually creating billionaire judges who, when you ask to go and sin no more, they just simply go with whatever, you know, they had been alleged to have, you know, garnered, and then, you know, go enjoy their life quietly.
It's amazing that everyone is quiet about this issue. Perhaps it will come up again when there's another executive judiciary tussle. But let's move on. Yesterday, 2 hours of screening for the substantive CJN, and he was quoted to have mentioned that there is corruption in the judiciary as it was in the larger society, recommending some form of punishment to be meted out to corrupt judges. Some are saying that, oh, for the first time we're hearing a judge admitting that indeed there is corruption.
A lot of judges have admitted that there is corruption.
Yeah, but this is coming from the CJN.
A lot, even the previous one had also admitted. At various fora and seminars, judges have admitted that the judiciary is not what it used to be. I just told you about Justice Kayode Esho of blessed memory. So many. And then also recently I was listening to a former chairman of the NBA, senior advocate of Nigeria, Okpoko, and he said, he did also admit that even the way judges are appointed these days, you know, the way lawyers in the Ministry of Justice are even appointed, unlike those days, you know, you have to be competent. But now, even matters in court, you hear that, well, the lawyer in the ministry is not even in court and there is no excuse for it. And, you know, these are some people also that graduate to become judges. And even the way some of the judges are appointed, the bearer is from me, please appoint him and we cope. And, you know, in some cases, you see judges lobby. That also takes away the shine from the very hardworking ones. I'm currently at the tribunal, election petition tribunal in some states, and I see the industry that some judges put into, you know, their work, sitting Monday to Monday, every day. Sometimes we leave tribunal at about 7, and they still do, you know, take manual recording. I see, you know, the effort, the industry that they put into the work. And so for some of these ones that are very hardworking, it takes away the industry and the shine from them when, you know, there are few corrupt ones who have not been able, who the system have not been able to, you know, eliminate. And so it also would be, you know, unfair of us to sit down and, you know, just in one brush, just sweep all of them aside, taking away those other ones that are very hardworking, that who, you know, are giving their all to ensure that justice is not delayed, and also that the windmill of justice do not grind slowly. And then lastly, that justice prevail if even the heavens will fall.
I get your point precisely. So now Justice Muhammad wants stiffer penalties for corrupt judges. As a matter of fact, he's called for a holistic review of the criminal law. Do you consider that the right step in the right direction? Some are saying that what we have had, or the challenge we have right now, is the implementation of this law, not rather new laws, so to speak.
I agree with that position, that our problem is really not lack of laws, but lack of the willpower to implement even the existing one that we have. And so that's why you find that even at some point when we attempt to, you know, implement them, we either do not go the whole hog, or we even circumvent the law trying to implement the law. And so you find out that when you do that, because law look at processes also, the process you employ to admit or to obtain a statement from an accused person is as good as the statement
you got.
Because you won't go to court and say, well, he made confessional statement. The court will first and foremost look at the process you employed to obtaining that confessional statement. And so that's why processes is very important. And so if you employ the wrong process, intentionally what you're doing, you are creating a loophole for the alleged, suspect or the defendant to find his way out. And so that's why for me, I think we should first and foremost look at the processes that we have employed so far to prosecute or to bring these persons to book. Once we look at the process and we tweak it a bit and ensure that we follow through the process, or we refine it to meet up to current day standards, then it will be easier for us to now bring more people into the drag net.
Whose responsibility is that? Is that the police responsibility?
Yes. The investigating, prosecution starts from investigation. And that is why, because the law, our constitution presumes you innocent, even if I catch you red-handed. It presumes it is not for you, once you are dragged before the court, it is not for you to begin to prove your innocence. The prosecutor will first have to prove beyond reasonable doubt. And what is reasonable doubt? That if there is any doubt in the mind of a reasonable man, that doubt should be resolved in favor of the accused person. And so, once you create a doubt in the mind of the courts, even if the defendant committed the offense, he can come and say, well, since you have not been able to establish, the offense against me, and then there is no case for me to answer.
I get your point precisely.
No case submission.
It just looks like we get carried away when someone is allegedly caught, and then
it's sensational.
It makes the headlines, and then we don't do due diligence.
And then the processes, we forget the process, but the court will not say because the matter had been sensationalized in the media, and so for that justifies a conviction.
Let's bring in a caller in very quickly. It appears like a heated conversation already, and Tosin wants to give us his thoughts from Ilorin. Good morning, Tosin.
Hello, good morning.
Good morning. Go ahead.
Yeah, please. What the CJN did is of great value because he wants to clear what is within his own territory before he can proceed to the entire masses. I think he has done a great job.
Well, thank you for your contribution, Tosin from Ilorin. The substantive CJN mentioned that there are loopholes in the law.
That's what I'm saying.
And that is what these suspected criminals take advantage of.
You see, Nifemi, let's tell ourselves the truth. Like when the DSS raided Judge's house, and then everybody was, oh, yes, it is good. I said, look, what you have done, you've created a loophole for all of them to escape. Except you really don't understand the Nigerian judicial system. You've created a loophole. You have to be systematic. You have to be strategic. And so once you do this, even others that you have not raided, you've given them an opportunity also, to cover their tracks. And when you get to court, the court is going to look through the processes. It's a standard practice. And in looking through the process, the court will definitely, you give them opportunity in some cases to be biased because we're talking about their colleagues here. And so once you create that opportunity to be biased, they all will follow that narrow path. But that's why they say as a prosecutor, you prepare a watertight case so that once confronted with the proof of evidence, the defendant will have no other option but to say, you know what, please, I want to plead guilty. If I plead guilty and, avoid long prosecution, what can you give me in return? Let's do a plea bargain. But when your investigation creates loophole,
it's already shoddy.
Already, the defense is looking at those loopholes and say, you know what, I want to go the whole hog. And then midway, he says, well, you have not been able to establish a case against me. And so that's why for me, let's look at the NJC. Because we have said this, we can't say it enough. The NJC has presently constituted about 85% of the members of the NJC are nominated and appointed by the sitting CJN. And we almost, ran into a constitutional crisis with Onogen's own until some members, a retired Court of Appeal justice had to step up on the plate to ensure that, the right thing is done. But there is need for us also to look at the way the NJC is constituted and ensure that you have an NJC who also is able to sit not on ad hoc basis, but to deal with matters
And
as
make
they
independent
come. It's
decisions.
like who judge the judge.
Apparently. Let me hold you for a minute. Is Joshua still there from Ikeja?
Yeah, I'm still here.
Please go ahead with the contribution. From Egbeda, rather.
Okay. Good morning. I think I just want to say that the new CJN has started on a good note, I would say, by actually admitting the fact that there's corruption in the judiciary and that there's the need to actually do what is needed to ensure that that is dealt with. And of course, we have to talk about the need for the judiciary arm of the government to be empowered and made to be more independent to be able to function very well without much of the interference from the executive. However, I would like for the guests in the studio, because some of us actually lost touch with how it all started when Onoge was removed. I recall at that time, at the CJN, who should be sworn in any moment for now, the president, there was also an indictment. It was also indicted, I recall. There was issue of himself also being indicted and an issue around corruption and also having some lot of money in his bank account at that time. I really don't know how that was resolved. In order not to, again, leave doubt in one's mind that even this one who should be sworn in now also has some skeleton in his cover. I don't know how that issue was resolved. I don't know whether the lawyer, Liberals, can also give us what happened with that case. Thank you.
Thank you for your contribution, Joshua. Apparently, there are huge allegations that come up when you have been appointed. But do we have a structure that investigates before we begin to put the burden of office on these individuals?
No, we over time, from what we have seen, there are really, even if we have structures, they are not watertight. Watertight investigations are not done. Once you are the anointed one, once you are anointed, some of these issues are glossed over, and then, until the day you step on the wrong toes, that's the day you'll be reminded that, look, you have some skeleton that we overlooked, and so it is the right time to bring them on board. And so, if you remember, like the caller had said, there were certain allegations of qualification, even though those had been investigated and they found out that they were just, they can't be substantiated. Initially they said the man read Sharia law because he was a Sharia court judge. But he was called to the bar, and then from there he was elevated to, Court of Appeal, and then later to the Supreme Court. And then also there were some people who made allegations of corruption. I don't know if those allegations were investigated by the EFCC and a report subsequently issued. I wouldn't.
The challenge has always been the political coloration that bedevils the dispensation of justice, as it were.
Yes.
But the substantive CJN was smart enough yesterday to have shed the burden on other arms of government.
That's what I'm saying.
You hear him say that there is a need for financial autonomy.
Definitely.
For the judiciary.
I was coming to that. Lagos State, for example, at a point in Lagos State, the magistracy, there was an attempt to place the magistracy in Lagos State under the ambits of the Attorney General. And thanks to people like our very good friend, G.T. Ogunye, who, took up the matter, public interest litigation, went to courts, and then eventually that idea was dropped. And then also there have been this battle for financial autonomy for the judiciary, where you see the state government drawing budgets for judiciary. In Lagos State in 1999, when the current vice president was appointed as the Attorney General, in one of the seminars during the campaign that we attended with him, he said one of the burden he faced as Attorney General was, having to visit judges, and he saw some of the judges, writing with lanterns. And then he was like, how do you expect a man like this not to be corrupt?
Please hold that thought for a minute and we'll get back to it. George is calling in from Ikeja. Let's have your thought very quickly. Good morning, George.
Good morning, Ifemi.
Good morning.
A point of correction first. The former CJN, that is Justice Onome, didn't admit that there was corruption in the judiciary. On the contrary, he was saying people should come and prove to him that there is corruption in the judiciary. So that must be corrected.
Okay.
The current CJN is saying that he is worried about corruption in the judiciary. But for me, the real issue lies with the judiciary itself, especially as it pertains to the NJC. The role of the NJC, as it has turned out recently, has turned to a case of someone being a judge in his own case. The NJC originally was to try judges or to sanction judges who commit offenses in the course of their judicial functions. But they have taken it further now that even if a judge commits a criminal offense, NJC must agree or try that judge before a court can try that judge. I want liberals to clarify that. Is that what this NJC law says? So the NJC, in my view, has become clogged in the whole process. I think that is what the CJN should look into. Even if you want to recommend these penalties, who is going to execute them?
That's all right.
This is my worry.
Thank you for your contribution. You want to react very quickly to that?
Yes, quickly. That's why I talked about the NJC, because the responsibility placed on the NJC are enormous. And so when you have an NJC that sits on ad hoc basis, it becomes difficult for them to discharge this responsibility. It is not out of place for the NJC to, just like the police conducting orderly room trial or the Nigerian Army court-martialing, an army person, and before handing them over to the civil authority for prosecution, to protect, the office of the judge. And that's why some of those recommendations are made, that, look, the NJC will need to look into such allegations, make recommendations, and then dismiss such judges and hand them over to civil authority. But when you have the problem is, when you have an NJC that sits on ad hoc basis, you're going to have cases piling up. Why these persons are still sitting, dispensing judges, and there are humongous allegations hanging over their heads. And because a judge is supposed, like my late professor would say, a judge is supposed to be a man whose ideas are up in the heavens, and that's why they are addressed as my lord. But when you now begin to have situations where, judges, even the mode of appointment are questionable, you also need to move the NJC, allow the NJC to move with time.
But who has the responsibility to fix all these challenges?
The National Assembly.
The National Assembly.
Yes.
Let's take this conversation quickly to Dr. Emu. Good morning, Yakub.
Alaji Yakubu.
Yes,
Once you mention Dr. Emu, I know that's Alaji Yakub.
Thank you very much, liberals. Good morning.
Good morning, Alaji.
Yeah, thank you very much. For me, I think the new CJN, what I want the old man to do for us is this. I'm looking at a situation whereby
At 65, do you consider him old?
Special call to try the corrupt person. Because in the case of all these corrupt political office holder, that the case will drag on and on and on and on. In fact, some cases since 1999 in the court up to now. So, but the question is that do we have the human capacity, as Lebron said earlier, all those manual recording, the Nigerian state should be able to provide the necessary thing for all these our judges, because they are working under the unconducive environment. So if they can be able to give them what they really want, so that they can be able to dispense these doors to every people. Because if there is a special court to try the corrupt people, I think they will be fast-tracking. But my question to liberals is this. If somebody that's a judge commits a crime in a marketplace, as in, for example, maybe he discharged a gun, he killed somebody in a marketplace. Does this mean that very particular judge should be go through the NJC before he tries the court of law? Thank you and God bless you, sir.
Well, thank you for your contribution, Yakub. Let's begin with the first one. The fact that has it not gotten better with the judges? They don't use lanterns again, do they?
No. That's the area I was coming to. And so for the current vice president, then Anthony General, he felt the first thing would be, to elevate the welfare of this personnel, and then before you begin to talk about, discipline. And so, they looked at the total welfare package. That was when they started, you giving them houses in, highbrow areas.
That's right.
And you retire, with your house. So you don't have to be bothering, how do I get money to build a house? You're given a befitting car and befitting allowances, so you also can send your children to good school. And after doing that, do you remember also about 30-something magistrates were sacked on the same day in Lagos, and the heavens didn't fall after painstakingly passing through the right processes. But after they were sacked, there were no prosecution, and so. But with that, it brought a lot of discipline to the judiciary in Lagos. And then there were also other innovations like the alternative dispute resolution. And then at that point also you had some monitoring in some of the courts to even determine when courts sit and when they rose and, judgment. All these are jobs also that the NJC, they get, feedbacks from, But because it is just one body, let me also tell you quickly. In Lagos State, for example, we have about 70-something high courts. And all the matters from this appeal from these courts, go to two courtrooms. But you might have like 3 or 4 panels of the Court of Appeal. And the same thing in the Court of Appeal in Ogun attends to, yes, matters from Ogun State. But the Court of Appeal in Ibadan covers Ibadan, Oyo, and Ekiti. The Court of Appeal in Calabar covers Cross River and Akwa Ibom. And so all cases from these places goes to this one Court of Appeal. You can have 2 chambers or 3 chambers as the case may be. And of all the 20-something Court of Appeals in the Federation, all the appeals from these courts goes to 3 chambers of the Supreme Court. And so that is why now you are having Supreme Court adjourn matters to 2023. Even Court of Appeal, Lagos, already adjourning matters to 2022. And so when you have this, and yet you say justice delayed, we admit that justice delay is justice denied. So all of these are some of the bottlenecks. And when you now say, as we speak now, of all the judges that are at the Election Petition Tribunal, matters in their court will stay.
It's all right. Let's take a commercial break now. When we return, we'll talk about the need for the establishment of special courts. Some have mentioned that there is a need for special courts for corruption, and also answer Yakub's question if the NJC will be required when the judge shoots in the marketplace. We'll take a commercial break now and be right back. Do join us again. Hello and welcome back this morning, and we're talking about moving forward for the Nigerian Judiciary. Yesterday, the Senate confirmed Justice Tanko Muhammad as the substantive Chief Justice of Nigeria, and he has admitted that there is indeed corruption in that arm of government and the need for stiff punishments to be meted out to corrupt judges. While I'm having a conversation with Liberals Oshoma, lawyer and human rights activist, thank you for staying the course on the show this morning. All right, so the issue of establishment of special courts also was raised yesterday. Some are saying that it appears to have worked for electoral matters because with the tribunals, with the election tribunals, you know that within a stipulated limit of time, you get justice. It has happened for elections in the past. Will it also work for corruption?
Corruption, unlike election petition, is broad. For election petition, it comes once every 4 years. For other election matters, it goes to the regular court and appeal can lie as far as Supreme Court. But for the conduct of the election itself. And so if you're creating special courts for corruption, you also have to define what corruption is. Because nepotism is a form of corruption. You might not have financially be rewarded for that act. But when I use my office to ensure that only people from my side are employed in, a place that is, managing. It's a form of corruption, corruptly ensuring that, the process is tweaked to favor, a certain section. These are a form of corruption. So all of this, is it going to be under the purview of these same special courts? And so when you create it, you're going to create special judges to handle those matters. But what Lagos State government has done, because we're talking about constitutional amendment also that at the initial stage might create bottleneck. But what Lagos State government had done is, look, we agree that you need more hands in this area. You need human capital. Because a situation where you have 10,000 cases investigated and you have about 20 judges to try them, definitely there's a deficit. So you appreciate the fact that there will be need, there will be need for more hands. So that the justice will be dispensed timeously. Justice Fatai Williams of blessed memory once said that there were days when you start a case on Monday and by Friday you were delivering judgment because the cases were fewer and, the hands were more. But now that's no longer the case. And which is why Lagos State government started the ADR. Cases that are not too contentious, you can take them to a dispute
Perhaps
resolution.
it's also high time we began looking at
then
reducing crime apart from looking
at that's where I'm coming to now.
But so let me hold you for a minute, Liberals, to take this call from Abia State. Good morning, Okorafo.
Yes, that's from
Good morning,
Amovi.
Good morning, Sani Femi, and our guests in the studio.
Good morning.
Good morning.
The gentlemen in the studio, some of our courtrooms now have been turned to charge and bail. What do I mean by charge and bail? Now, look at, let me take for example, a crime was committed, a crime of 5 million, and the judgment, the judge will tell you pay 30,000 or you go for 2 months imprisonment. Or now look at another case too, a crime of 50,000 naira. You tell the person that you go for two years imprisonment. Now compare the two. This is the judicial system in Nigeria. The constitution we are talking about, they should look into it very well. Because the penalty we give in some cases and start making the people that we that are listening, are watching the television and listening, we start wondering, is that what type of thing we should be taking? That's why I get this today now being trapped. Now look at the issue of Evans, the kingpin. Now tell me, every day when you go, either the judge or the lawyer or the thing, is that how it's supposed to be? This is a case that at least we know at least within 6 months. This has to be just clear. As like other cases. Now that is why I'm suggesting on this program that police stations, they should have lawyers or people that are criminology.
They have.
Whether they have, when you talk about they have, how tested are they?
They are.
That is the question. How tested? Do they know the implications of all these things? Because it is not a question of going to collect the certificate and collect the job and sit down in the office and you don't know what you are doing. That is not what it is. We're talking about people that are ready to do the job and to implement the system so that we reduce all these issues of cases every day and go to police station, go to the prison yard, everywhere, fill up with people. Adjournment.
That's all right.
We should call this very speed. Thank you very much. Have a blessed day in Lagos.
Thank you indeed for your contribution. We have to move ahead very quickly. The issue of independence of the judiciary. So the Justice Muhammad alleged that some governors pose huge challenges to the independence of state judiciary. A situation
Not just
where
the state judiciary.
they don't pay.
These are some of the issues that even some lawyers are complaining about in as far as the appointment of the CJN is concerned, that there were interference, from the executive, and so that also does not enhance independence. And so when you tweak or manipulate the process, and then that was what I was talking about, leaving the process hanging.
That's right.
And then you give room for people to say, look, this process was actually tweaked to produce this desired end. And so that means there were no independent. And so to some extent, that there's this presumption that the judiciary will do the bidding of the executive. That's also, some form of independence.
I'm just wondering who is going to hand
and
over.
So with that, when that happens, you embolden the state governors to begin to interfere in the appointment of justices and in the appointment of, chief judges. You remember in Rivers State during the administration of Rotimi Amechi, the courts were closed for a year plus over disagreement between the NJC and the state governor on who becomes the
Let's take
CJN,
this call very quickly from VI.
States.
Good morning, Okpara.
Yeah, good morning.
Good morning to you.
And good morning to Mr. Lebros.
I greet you, Mr. Okpara.
Yeah.
We thank God for the new CJN. And please, what I want to request is, please, what we are seeing in Nigeria today, just as my fellow callers have said, in the various states, we are finding it difficult. A case to last for 5, 6, 7 years. Case of land dispute issue in the court for 5, 6 years, getting to 7 years.
12 years in some cases.
It's not related. Please, you think that we are lacking capacity? Helping hands, no more lawyers in this thing that we divide. Let there be division of this thing. So then, if there's any this thing, they have protection that we handle that thing. But you see, in the various states, we don't have enough hands to handle the case of paper. Every time, adjournment, 5 years, 6 years, 7 years. Look at Lagos. The court of this thing, the workers' court in the VI.
Yeah, industrial court.
Industrial court. For 6 years now, a case has been there for workers, and it has not been, nothing has been done. Every time, adjournment. Let the chief judge of the federation, let them sit to this and get capable hand to handle, because people are spending a lot of money. Anytime you are joining, you are paying lawyers, and they are just ripping up people like that. Please, I don't know if there is any section one can report this thing to, and let them handle it. Please, thank you.
Thank you, Mr. Okpara, for your contribution. It's quite disturbing, especially when you look at the number of people in our prisons simply awaiting trial. But how much work do you see the Ninth Assembly doing in this regard? Well, we talk about independence and financial autonomy for the judiciary.
Very little, because first and foremost, the things that would enhance welfare of the average man, it's not paramount in the mind of our politicians across boards. And then also, some of these issues are not well laid out either in manifestos or electoral promises. And so they just say, we will reform. Reform is vague and ambiguous. You need to pigeonhole those reforms so people can, brainstorm on it, walk through it, and then refine it so it becomes better. Lagos State, I always mention Lagos State because I practice law here. When it became difficult to create special courts because they know it will take constitutional amendment, what the government simply did, Judiciary simply did, was to, through practice direction, segment the courts into divisions. So you have criminal division, you have general civil, you have commercial division, you have probate division, and so if you have a civil matter, you know where it will go. If you have a criminal matter, you know where it will go, and so it makes it easier. And then you now know you'll be able to at least take a data of the number of cases of the area where you need more hands. So if criminal cases are more, and you can now collaborate with the prosecuting authorities to say, look, the rate of criminality in this state is high, so there's need to collaborate and check crime. And then there's also need to increase the number of the division in such area.
Apparently.
But in other states or at the center, these are not the same thing. And so that's why in some cases it's difficult. And like Lord Denny said, when a judge sits on trial, the judge is on trial. And that's why we come back to the NJC. When a judge is on trial, who is trying the judge? Who is looking at to ensure that, the proper thing is done? And then also case management. Some lawyers, we agree, there's some lawyers intentionally delay cases. I'm also guilty of it in some instances. But when there are, like Lagos State tried to introduce sanctions, even though the sanctions were punitive.
That's right.
100,000 naira for an adjournment, they were punitive, and the MBA, kicked against it. But it should
Let me hold you for a minute to take this call from Ofa. Good morning, Enoch.
Hello, good morning.
Please go ahead with your contribution.
Please, what is the help of the common man? Because I have issue with one lawyer at time during that time. Yes, he helped me to secure a land. Unknowing the land, he sold the land to another person entirely. So I have to secure a lawyer. They are now adjourning at least like 5 years ago now. They are using the influence of being a lawyer to maltreat a common man. What the stake of the lawyer has in the help of a common man in this kind of issue?
You know, these are areas where the NBA has failed, you know, the common man in some instances, where you complain the allegations against lawyer, and then, yes, you know, foot dragging to see it to the end, you know. And so I would still recommend, you know, in such cases, he should do a letter to the NBA, also do a letter to the Legal Practitioners Disciplinary Committee, you know, complaining against the attitude of the lawyer, you know, because these are, you know, grievous
Imagine
offense.
the financial and
yes,
emotional
this,
burden
it's a breach of
going to court for the same matter for 5 years.
Yeah.
Indeed. Let's look at some other issues very quickly because of our time. It's interesting how these things are played out. But even when you get justice in court, it's another thing to have it implemented. So we've had a lot of court orders that have been disobeyed by the executive. People are saying, oh, what is the place of respect for court rulings, the rule of law, and who in this case has the capacity to enforce it?
You know how helpless it is as a judge. You sit down, you day and night, hear a matter, go back into chambers.
Before you answer that, just a minute. I understand we have a caller from the FCT. Good morning, James. You have the floor now.
Hello, good morning.
James, go ahead with a contribution, please.
Okay, good morning.
Good morning.
Good morning, Mr.
Good morning.
Somebody asked a question, asked liberals a question about the chief judge when a judge commits an offense. I mean a criminal offense.
Yes,
if
yes.
he is to be taken to the CJN. The liberals have not answered it.
All right,
Okay.
let's answer that very
People
quickly,
are
liberals.
interested in it.
Yes, yes.
Okay, please do.
Yeah, you see, first and foremost, because they say when trees falls on trees, first the topmost are removed. I told you, judges, the people you appoint to the bench ordinarily should be people who would not, you know, reduce themselves to the level of having to get involved in
But
petty.
what happens
Wait, no, I'm
when they
coming
do?
there. Wait, no, wait. Ordinarily, you know, into petty crime. But now that people are beginning to think about it,
right.
there is need for us to create a divorce between the conduct of a judge, you know, when dispensing his duties as a judge, and the conduct of that judge, you know, in the ordinary course of event, as a citizen of Nigeria. There's no need. I don't think the NJC should get involved when a judge commits a crime, not in the course of his duty as a judge, like this stance they gave. You have an altercation with somebody in the marketplace, for example, and you say, do you know who I am? I'm a judge. And then you pull out a gun. In such cases, there should be an arrest immediately and possibly collaboration between the NJC and the prosecuting authority.
Is that the case as is it now?
As it is now, with the Court of Appeal judgment, that judgment says, irrespective of the offense committed, that the NJC has the power to look into it, even though it tries, the Justice of the Court of Appeal try to distinguish between the duties of the judge,
the office of the judge,
and it's you know,
and
private
the person
life.
of that.
But that's where also, if we cannot create, you know, that divorce, what we should do now is to have an NJC that would be activated immediately upon the commissions of this crime, so that we don't have to wait and then do a petition and then begin to wait for 1 year, like I said earlier, and yet that person is still sitting as a judge. So
we'll get to the issue of the respect for court rulings, but we have Biola calling in from Ian Opaja. Good morning, Biola.
Hello, good morning.
Good morning to you.
Yes, actually, I have a case at hand. I work for Global Scan Systems. Are you with me?
Yes, we are.
Yeah, and it's an inspection agency. You know, Global Scan System is the only indigenous company in the whole nation owned by Emeka Ofo.
But I'm not sure that we have the liberty to take this, especially when you've started mentioning names.
Okay, I'm sorry, but
perhaps you will have to call us back. It really sounds like a private matter, because this is not liberals, Femi and Co.
Yes, this is not illegal aid.
So I'm afraid that we can't attend to this matter right now on air, but you can call liberals later. He's a lawyer and he can really attend to that. So let's talk about, you were talking about the frustration of judges.
Yes.
When there are court rulings and they're not respected.
You know how frustrating it is as a judge. You spend day and night, day listening to a matter, night in chambers, you know, perusing through the leaves of your notes, and then you come up with a 75-page judgment only for somebody to sit down somewhere and tell you that, well, we are still studying that judgment, whether to obey or not, and then stylishly avoiding, obeying that court order. You know how frustrating it is as a judge. And so that's why also when the CJN, was talking about independence for the judiciary, it also was talking about the judiciary being able to enforce orders against persons or government agencies irrespective, because if you commit a government officer to court, for example, who will execute such committer, it is the same government. And so what if they decide to look the other way? And so when you do that, what you're telling, it's like a last mile official who is driving against traffic, arresting a downful driver for driving against traffic.
Does this independence mean that the police infrastructure now will answer to the judiciary in enforcing?
No, not necessarily. The independence means that you strengthen each arm to be independent. Take, for example, the Metropolitan Police does not have to look at the body language of the mayor or the prime minister to arrest a member of parliament who commits an offense, or that his job is dependent on whether he arrests him or not. And so if he does, that he will be, his job is at stake. It's an independent arm. It's answerable exclusively to the Police Service Commission.
I get your point, Liberals.
Those are some of the independence that the judiciary is talking about. If the judiciary alone enjoys that independence, and the agents and organs of government that are statutorily responsible to discharge, consequential orders made by the judge are not so independent, then we're back to 1.0.
Let's take this conversation to Dublin Island. Samson is on the line. Good morning, Samson.
Good morning.
Good morning to you. Go ahead with your contribution.
Thank you. Since now Nigeria is trying to get it right, I think the best thing for us to do now is to copy other nations that have done it successfully. Okay. What am I trying to put across is, if you have a case, either any part, I've lived in London, in Germany, and so on. If you have a case,
what's chasing
your lawyer will want to know the truth about the something. And even if you commit an offense, they will ask you to plead guilty. In order to, but it's not about Nigeria. You see someone kill somebody, you just want, just because you have the money to know. I think there should be I'm not a legal practitioner, but what I'm trying to say is that they should find a window where they can, amend one or little things that the lawyer should be, to have a national interest for.
I think we get your point, Samson.
I get your point.
I thank you very much for calling in.
What he's saying is, it's simple. Here, you find out that, there's this esprit de chop, there's esprit de corps. and so, esprit de chop, if you're a lawyer, you commit an offense, and I'm a lawyer, that's the tendency for me to want to look the other way because my colleague is involved would be there. But if the body responsible to sanctioning lawyers is immediately activated to look into, such an offense and then sanction that lawyer, in some cases even withdraw his practicing license, even in matters that he's involved in, then a lot of people will sit up. Take the case of Iburi, for example. Even his lawyer also was investigated and sanctioned, and he went to jail for advising him, against the norm. But here, lawyers, you confess to a lawyer, the man will say, well, let's wait for the prosecutor to prove. Because he also knows that the prosecutor will do a wishy-washy job.
We have to
be difficult.
Tidy this up now, Liberals, very quickly. Let's look at the person of Tanko Muhammad. He now has the responsibility to redeem the image of the judiciary, and it is set a higher standard for rule of law. But Justice Ibrahim Tanko Muhammad, called to bar the same year he left law school in the 80s, Chief Magistrate of the High Court of the FCT, became judge at the Bauchi State Sharia Court, appointed to the bench at the Nigeria Court of Appeal, and then bench to the Supreme Court of Nigeria. Earlier this year, appointed as acting CJN. Do you see him as a man who has the capacity to make all of these desired changes?
He's traversed the length and breadth of all the courts in Nigeria. All. From the magistrate court, apart from customary court, from magistrate courts to Sharia courts, to
The
Court of Appeal,
and then the Supreme Court.
And then the Supreme Court. And so, yeah, because in the North, if Sharia courts, they do the job of customary court here. Yeah, you can say he's not been at the High Court, but, he sat as a Court of Appeal judge, taking appeals from the High Court. And so he understands, he should understand, what it takes to transform the judiciary. And also, I don't want to see excuses or hear of excuses that in some cases where you hear my hands are tied. Most especially also see some lawyers also alluding to the fact that, the way he was appointed, it means that he was appointed, to favor certain persons. And so this is the time for him to rise above board, to prove to everybody that, look, the judiciary can no longer sit on the same place.
We have to go now. I know that we can have this conversation for yet another hour. Libras Oshoma is a lawyer and rights activist. Thank you very much for joining us on the show today.
My pleasure.
I'm looking forward to a working relationship between the three arms of government, and hopefully this time President Buhari has gotten a CJN that he can work with. We'll be back tomorrow, and Kuyori will be on the show. Until tomorrow, ensure that you are a good civilian or a good citizen of Nigeria who wouldn't need the judge or the judiciary. I am Nifemi Oguntoye, and thank you for joining us.